South Carolina has a landlord-friendly tenant screening environment with minimal state-level regulation beyond the federal baseline. The state's overall approach favors property rights and gives landlords broad discretion in screening and selecting tenants. The governing framework includes the South Carolina Residential Landlord and Tenant Act, found in South Carolina Code Title 27, Chapter 40, along with FCRA and the South Carolina Fair Housing Law. Let's start with application fees. South Carolina does not cap application fees. There is no state statute limiting what a landlord can charge an applicant for tenant screening. The South Carolina Residential Landlord and Tenant Act does not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable to cover the cost of screening. While there's no legal cap, keeping fees proportionate to actual costs is good practice. Most South Carolina landlords charge between $25 and $50 per applicant. Charging significantly more than the actual screening cost can discourage qualified applicants and raises questions about whether fees are being used for profit rather than legitimate cost recovery. Criminal history screening in South Carolina is unrestricted at the state level. South Carolina does not have a ban-the-box or fair chance housing law. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can apply criminal history criteria without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. No South Carolina municipality has enacted local criminal history screening restrictions for housing. Charleston, Columbia, Greenville, Myrtle Beach, and every other South Carolina community operate under the same unrestricted framework. South Carolina's preemption authority and political environment make it unlikely that individual cities will enact local screening restrictions that differ from the state's market-based approach. HUD's 2016 guidance on criminal history and disparate impact does apply in South Carolina. Blanket policies that automatically reject every applicant with any criminal record can violate the Fair Housing Act if they disproportionately affect protected classes without legitimate business justification. South Carolina landlords should document their criminal history criteria and apply them consistently, considering the nature of the offense, how long ago it occurred, and its relevance to the tenancy. This isn't required by state law, but protects you under federal fair housing standards. Source of income protection does not exist at the state level in South Carolina. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. No South Carolina municipality has enacted a local source of income protection ordinance. Participation in voucher programs is entirely voluntary. For credit reports, South Carolina follows standard FCRA requirements: permissible purpose, written consent, and adverse action notice procedures. South Carolina does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond the federal baseline. The standard FCRA adverse action notice is sufficient. South Carolina's fair housing protections are found in the South Carolina Fair Housing Law, South Carolina Code Title 31, Chapter 21. The Act prohibits discrimination in housing based on race, color, religion, national origin, sex, disability, and familial status. Mirroring the Federal Fair Housing Act, South Carolina has not added additional protected categories such as sexual orientation, gender identity, marital status, age, or source of income beyond the federal baseline. The South Carolina Human Affairs Commission investigates fair housing complaints and can take enforcement action. While the state law mirrors federal protections, recent federal interpretations of sex discrimination may extend some protections based on sexual orientation and gender identity. South Carolina landlords should be aware that this area of law continues to evolve at the federal level. One aspect of South Carolina's landlord-tenant law that indirectly affects screening The state's eviction process is moderately efficient, but not as fast as some neighboring states. South Carolina uses an ejectment action through the magistrate's court, and the process typically takes 3 to 6 weeks for uncontested cases. This moderate timeline means that screening errors take a reasonable amount of time and money to correct, reinforcing the importance of thorough, upfront screening. From a practical standpoint, South Carolina's rental market has been one of the fastest growing in the Southeast, driven by strong population growth, corporate relocations, and the state's appeal as a lower-cost alternative to higher-tax states in the Northeast and Mid-Atlantic. Charleston has emerged as one of the most desirable rental markets in the Southeast. The city's economy is driven by Boeing's manufacturing operations. The Port of Charleston, one of the fastest-growing ports on the East Coast. Joint Base Charleston, the Medical University of South Carolina, tourism, and a thriving technology and startup scene. The Charleston Metro, including Mount Pleasant, North Charleston, Summerville, and Goose Creek, has seen significant rent increases and strong demand. Landlords in Charleston generally have strong pricing power and a deep applicant pool. The military presence at Joint Base Charleston, which encompasses both Air Force and Navy operations, generates substantial rental demand. Military tenants represent a meaningful portion of the Charleston area market, and landlords should understand military income documentation, leave and earning statements, BAH rates, and the Service Members Civil Relief Act. Charleston's BAH rates are competitive and support strong rental pricing near the base. Columbia, the state capital and home to the University of South Carolina, has a diverse rental market driven by state government, the university, healthcare, including Prisma Health, and Fort Jackson, the Army's largest basic combat training installation. Fort Jackson generates enormous temporary and permanent military rental demand. The student population at USC creates significant seasonal turnover near campus, and landlords screening student applicants need a consistent approach to evaluating thin credit files. Greenville has experienced remarkable growth and transformation over the past 2 decades. The city's economy is driven by advanced manufacturing, including BMW's massive manufacturing plant in nearby Greer, healthcare, financial services, and a revitalized downtown that has attracted young professionals and corporate relocations. The Greenville-Spartanburg Metro has a strong rental market with growing demand and rising rents. Landlords in Greenville benefit from a diverse applicant pool that includes manufacturing workers, healthcare professionals, corporate employees, and university students from Clemson, Furman, and other nearby institutions. Myrtle Beach and the Grand Strand have a unique rental market heavily influenced by tourism. The market has both permanent residents and a massive seasonal workforce that staffs hotels, restaurants, and attractions during the tourist season. Screening seasonal workers requires clear criteria for evaluating temporary or variable income. Have a documented approach that you apply consistently. The Myrtle Beach area also attracts retirees and remote workers, adding diversity to the applicant pool. Hilton Head Island and Beaufort have upscale markets driven by tourism, retirement, and Marine Corps Air Station Beaufort. Hilton Head's resort economy creates seasonal workforce housing demand similar to Myrtle Beach, but at a higher price point. Marine Corps Air Station Beaufort and the nearby Marine Corps Recruit Depot Paris Island generate military rental demand in the Beaufort area. Rock Hill, near the Charlotte, North Carolina border, has benefited from Charlotte's spillover growth. Landlords in Rock Hill screen a mix of local workers and Charlotte commuters. Spartanburg, Anderson, Florence, and Sumter have more moderate markets with varying demand levels. Clemson, home to Clemson University, has a tight student market. Screening in college towns requires handling high volumes of applicants with limited credit and rental history. A clear cosigner or guarantor policy applied uniformly to all applicants who don't meet standard income or credit criteria keeps you consistent and compliant. One best practice for South Carolina landlords: Develop a written screening policy that documents every criterion you apply. Even though South Carolina imposes no screening restrictions beyond federal law, documented criteria protect you against fair housing challenges. Your policy should specify credit score thresholds, income-to-rent ratio requirements, rental history standards, criminal history evaluation criteria, and how you handle applicants with limited credit history. Apply these criteria to every applicant without exception. Another best practice, for landlords in military communities like Charleston, Columbia, and Beaufort, create a military applicant screening checklist. Military income is among the most verifiable and reliable income sources you'll encounter. The leave and earnings statement shows exact pay, deductions, and allowances. BAH is guaranteed for the duration of the service member's assignment. Having a standardized process for evaluating military applicants streamlines your screening and ensures you're treating military applicants consistently with civilian applicants. A third best practice, for landlords in tourist markets like Myrtle Beach and Hilton Head, have clear criteria for screening seasonal workers. Seasonal employment income can be verified through employer letters, pay stubs, and tax returns from prior years. If you require a minimum lease term, which many landlords in seasonal markets do to avoid turnover during peak season, document this requirement and apply it uniformly. South Carolina does not have a statutory limit on security deposits under the Residential Landlord and Tenant Act, though the standard practice is 1 to 2 months' rent. The landlord must return the deposit within 30 days of the tenant vacating. While the flexibility on deposit amounts provides some financial protection, thorough screening remains your most effective tool for selecting reliable tenants. For the complete guide to South Carolina tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.